I hesitate to make a prediction early in the morning about what Kemi Badenoch is going to say at lunchtime, but I would dare. I would dare a little because I think she's going to talk about the ECHR. The human rights and the European Convention on Human Rights, the ECHR, are once again at the heart of British political debate, and the Conservative Party at the moment wants to make a fuss about it, with Kemi Badenoch positioned as a hardliner on immigration. So at PMQs this morning, I expect Badenoch will leverage her new policy stance on disapplying the Human Rights Act for all immigration cases. Now, following the rhetoric of figures like Rupert, Robert, Arthur, Loki, and Reform UK and Reform UK, this intervention marks a significant shift in the vocalising of this subject in the Conservative Party. The Conservatives have moved over the last 3 years closer to an outright challenge of Britain's participation in the ECHR. The it's extraordinary how we've actually got to this point. The Human Rights Act in 1998 incorporates the ECHR into UK law, ensuring that British courts apply its principles domestically rather than forcing individuals to seek recourse in Strasbourg. And the ECHR, established in 1950 and championed by figures such as Winston Churchill, enshrines fundamental protections, including the right to life, the prohibition of torture, the right to a fair trial. I should put my cards on the table. I was involved in a case that went through the European Court of Human Rights. It took 11 years to progress. It was successful. It was a case against the Greek Coast Guard. It doesn't appear to have been particularly efficacious because the judgment was that the Greek government should change its law in 4 instances. It hasn't done a thing. But in terms of a Pyrrhic victory, yes, it was achieved, and it took a long time. So I'm quite supportive of the process because even if right doesn't yield results, it needs to be acknowledged. It is acknowledged. Badenoch has declared that immigration cases should be exempt from the Human Rights Act, arguing that British courts have been extremely distorted by their interpretations of international law, thereby undermining border control. And she has framed her proposal as a necessary shift of power from the judiciary to elected ministers, reinforcing a populist stance that echoes the Brexit-era mantra of taking back control. Under the proposed amendment of Border Security, Asylum and Immigration Bill, in this particular bill, which is going through Parliament at the moment, the Human Rights Act would be disapplied to all immigration-related legal challenges, she says. Migrants seeking an appeal to appeal deportation on human rights grounds would have to petition the European Court of Human Rights directly in Strasbourg, and the UK government would have the power to ignore last-minute interim ECHR rulings blocking deportations, so-called pyjama injunctions. If enacted, Badenoch's proposal would revert UK immigration law back to its pre-2000 state before the Human Rights Act was introduced by the Blair government. And while the UK would technically remain a signatory to the ECHR, British courts would no longer be able to consider its provisions in immigration cases, significantly altering the domestic legal landscape. The move has sparked some debate within the Conservative Party, with some advocating for a full withdrawal from the ECHR, while others warn of the diplomatic and economic ramifications of even this modification. The ECHR is embedded in various international agreements, including the Good Friday Agreement and post-Brexit trade deals. Leaving or weakening compliance with the ECHR could jeopardise the UK's international standing and relation with key allies. The likely themes in Badenoch's PMQs today, therefore, would be to challenge Labour to support the amendment, framing any opposition as evidence that Starmer's government is weak on border control, to cite controversial immigration tribunal rulings to argue that the judiciary is obstructing deportations on spurious human rights grounds, to position her policy as a bold Conservative alternative to Labour's more cautious approach to immigration reform, and to evoke public frustration with small boats crossings and high-profile cases of foreign nationals avoiding deportation because of human rights claims. Labour The Lib Dems and human rights groups have already criticised the proposal as legally unworkable and an affront to fundamental protections. The Home Office itself has labelled the policy unworkable, noting that the Tories had 14 years in government to address these issues and instead spent millions on the failed Rwanda scheme. I don't think that's something that the Labour government can really hide behind, because it hasn't fully repealed the Rwanda law, or indeed the laws that supported the Rwanda scheme, like the human rights, like the nationality and borders law, and the I forget the other one now. Anyway, the key criticisms that will be levied against her are that even if the Human Rights Act is disapplied domestically, claimants can still appeal to Strasbourg, potentially leading to even longer legal delays. The international backlash will weaken human rights protections in immigration cases that could strain relations with the Council of Europe and the EU. And some people will argue that Badenoch's stance is more about positioning the Conservatives for the next election rather than implementing practical legal reform. Badenoch's intervention today will likely escalate the ongoing Conservative debate over Britain's relationship with the ECHR, and while her rhetoric will appeal to the right of the party and Reform UK supporters, and Reform UK supporters, it remains to be seen whether this policy will gain traction beyond political posturing. As the debate unfolds, PMQs will serve as a litmus test for how effectively the Labour government can counter these arguments, and whether the Conservatives will push further towards an outright break with the ECHR.